Yeah.
Thanks a lot.
Madam Chair, we are live.
All righty, welcome everybody to the Friday, January 17th, second installment of House Energy and Digital Infrastructure, the committee with a lot of questions. We are here today to learn about the Public Records Act. Let's quickly go around the table and introduce ourselves, and then we'll allow our witness to introduce himself for the record. Kathleen James, Manchester.
Scott Campbell, St. Johnsbury.
Richard Bailey, Lamoille 2.
Chris Morrow, Weston.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Territory, Washington 2.
Graham Kleppner, Chittenden 13, Burlington.
I'm spelling Wyndham 2.
Great, thank you so much.
Well, fantastic, and thank you for having me. I'm Tucker Anderson, Legislative Counsel and Records Officer. So I've been with the General Assembly for 8 years. This is my 9th session. And originally I started as a law clerk. I clerked under Betsy Ann Rask. So I got some very excellent training in the first few years of my legal licensure. I returned to Legislative Counsel after I was a clerk to be a Legislative Counsel, and was hired also as the General Assembly's Records Officer for the Office of Legislative Counsel and the other staff legislative offices. And for all of you, if you ever choose to use my legal services in response to a Public Records Act request. And this is my 7th year doing that. So I can riff endlessly on the Public Records Act. I've got all of the citations tattooed on my back, and I'm ready to go at any time. I sent some materials to the committee just 15 minutes ago, background materials that I have presented to new members of orientation and to other committees, including the committees of jurisdiction, the GovOps committees in both the House and the Senate. And I've updated them just based on some recent case law. I wasn't sure where the committee wanted to go this morning. We could do it jazz style. I could give you the 20,000-foot view, and you could ask questions as we go along. I didn't just want to read from the materials to you, but I can also do that. I'm a new father, so I'm getting very good at story time.
Great. Well, I see that they are posted on our website, so thank you very much, Jack and Tucker. I'd say assume we know nothing, and let's start there. So I'm at your presentation, Public Records Act's Introduction and Overview. I see 2 different documents. I'm not sure if they're the same one, but why don't you start, Tucker, and just walk us through what is the Public Records Act, what are its key provisions, and how does it apply to us as elected officials?
Fantastic. So I'll start by saying, don't be scared. I think that often my clients, and really anyone who's faced with a Public Records Act request, often have a lot of fear and trepidation about the process, making sure that you don't misstep, potentially fearing litigation down the road, possibly fearing embarrassment. But ultimately, the process is very well balanced and meted out, and it is not an intimidating or scary process. And you do have some fantastic Legislative Counsel attorneys who can represent you if things ever go wrong. The Public Records Act is Vermont's corollary to the Federal Freedom of Information Act. So in the introduction and overview, I note that the Freedom of Information Act preceded the Public Records Act by about 10 years. And when Vermont adopted the Public Records Act, it used some similar language, particularly in some of the initial exemptions that were built into the Public Records Act from FOIA, which is what I'll call the Freedom of Information Act from this point forward, and borrowed a lot of the spirit of FOIA, with one very notable exception. FOIA does not apply to the legislative branch of the federal government. But the Public Records Act, under its express terms, does apply to the legislative branch of state government. So the General Assembly wrote at bare minimum, its staff offices into what a public agency is under the Public Records Act. The most concise description that I can give you of what the PRA is that it is a procedure for members of the public to request access to public records that are created or acquired by a public agency. And pretty much every single term that I just used in that concise statement has its own unique definition, which has been litigated, and we have individual holdings from the Supreme Court of Vermont about what each of those terms mean and when they apply, which I have noted in the bullet point overview that you will now have at your disposal moving forward. The general process that plays out: a member of the public will contact an officer of the public agency and request a record. It does not have to be formal. They don't have to use, for example, some sort of records page where they submit a description. They could send an email to any employee of the public agency and say, I would like every email containing the word fish produced by the Department of Fish and Wildlife. Public records request.
Question and a request. Jack, can you put Tucker's PowerPoint up on the screen? I think that'd be helpful, even though we're not gonna, have you read it to us. I think it'd be helpful to just have us follow along. And Tucker, did you say that the records request, would it come to us or does it come to you? I've been FOIA'd once and I was notified by maybe you're gonna get to that, but it didn't come to me. I was notified that I'd had a request.
We'll get to some of the special things about you all, but it doesn't have to go directly to the intended officer, for example, the records officer of an administrative agency, or, if the request is for the commissioner's emails of the department, it doesn't have to get sent to the commissioner. The public agency itself just has to receive the request. In the case of you all as legislators, sometimes people send the request to the sergeant at arms. In fact, that's the most frequent point of contact for many people who are requesting records belonging to individual legislators. Sometimes I receive them because I am listed on the General Assembly's website as the records officer. People who are familiar with the Public Records Act know that means that I am in the kind of non-partisan officer position for receiving and making determinations on a request. Sometimes they'll send it directly to the legislator, committee assistant. They send it anywhere. In fact, you as an individual legislator could receive a request that names 5 other legislators who didn't receive the email. So drive that point home that they don't have to send it directly to the party that is the subject of the request.
Great.
If you'd like, I can use the presentation just as kind of a scaffolding.
It'd be helpful for me. I'm on page 3. I don't know what page you might be on in the jazz form.
In the jazz form,
Yeah.
page 3 is great.
Okay.
So we talked about the general right to public inspection and copying. Something to note about that is that there are frequent assertions that the Vermont Constitution contains a right to access to records, and the Supreme Court has already ruled on that and held that any constitutional provisions related to, for example, access to governmental proceedings, or specifically Article 6, which talks about the duties of officers of government, that those are not self-executing, and that the only avenue for access to records is through the Public Records Act. There's no enshrined constitutional right involved here.
Okay.
The definition of a public record: any written or recorded information, regardless of its form or characteristics, that is created or acquired in the course of the public agency's business. So a few things to note about that.
On page 4.
It's
Jack. That's okay.
So-
Just point to me when you need to change it.
Okay.
I'll come up with some sort of hand signal to be determined. So, as long as it's recorded, it meets the first test. So that could be something that is written on a paper calendar, on your wall, a memo, sticky note on your table. It could be an email that you've sent. It could be a text message, a GIF you've sent, the notes that you're keeping right now. So it doesn't matter what the form or characteristics of the record are, it's whether information has been recorded and whether it was produced or acquired in the course of agency business. And this is, as far as the definition of public record, the most recently litigated clause, and the Supreme Court reviewing an instance where a UVM professor had used UVM technology to create some research documents that were requested under the PRA. The Supreme Court determined that it is about whether the record was created or acquired in the course of the public agency's business, not whether it was created using the tools at the disposal of the public agency. So the test is really around, was this done in the course of the agency's business? Does it have a link to the agency's work versus is this something personal?
Mhm. So me using my personal email to discuss legislative business is completely included.
Correct.
Right, okay, because of the content of the conversation. Gotcha.
Whereas use of legislative email for personal business, like, happy birthday or something.
Right. Yes. As long as the record is not produced or acquired in the course of the agency's business, it is not a public record. So there's two decisions that talk about, where a record is located and whether it has any effect. And in both cases, one was a Tensing v. State case about accessing records that were on the personal devices of, I believe, the Attorney General's office. The court said it doesn't matter where they are. The test is this produced or acquired in the course of agency business? And they had the opposite holding about personal records that are kept on agency devices. The only note that I have about the definition of a public agency for you all to consider both in your personal capacity, but also in the work that you're doing in this committee, is that the definition of public agency is fairly broad and expansive within the context of not only government agencies, but government work. So first, for you all, each of you is a public agency.
Right.
And the reason for that determination is that you are independently elected constitutional officers. You are the head of your own agency. If I asked you who your boss is, you would say me, because you exercise all of the discretion and power over the duties of your individual offices. And you all have unique individual interests in carrying out your role as an elected representative. So you're the public agency. Simultaneously, when you gather as a committee to do work, this body is also a public agency. Gets a little more complicated there because you're all also potentially in conflict within that agency over the creation of certain materials. We can talk about legal tests for determining who's the agency if you ever get a request in the future. With the work that you do, recent decisions have taken a look at what an instrumentality of the state or a political subdivision is, and has determined that an instrumentality extends to non-governmental entities that have been delegated governmental functions. So if you are working with a bill that is going to task a non-governmental entity, or potentially fund a non-governmental entity to carry out a duty that is a distinct governmental function, that might be an instrumentality that would be subject to the Public Records Act.
An example of that would be, say, Efficiency Vermont, perhaps.
Perhaps I don't want to analyze an individual non-governmental entity
Sure.
live.
I'm trying to think of an agency that, or whatever, an entity that is carrying out a public purpose and gets funded through the state.
So there were two Supreme Court of Vermont cases back to back within the space of a few months on this particular issue. One was whether the Vermont School Boards Association was an instrumentality, and the court determined in that instance that they were not, because there was no governmental body involved in the control of that NGE, that there were no statutory duties established for that non-governmental entity where they were carrying out a function. There just wasn't a sufficient nexus between carrying out government work and what the VSBA is. So that was a no, not an instrumentality. However, there was another case, and that was about a nonprofit that provides medical services for incarcerated people in Vermont's prison system. And in that case, they said, yes, absolutely. This is an indispensable government function, one that is required by the United States Constitution that medical care be available to incarcerated persons. And the state, through statute and Department of Corrections rule, has delegated authority for this constitutionally mandated government function to a non-governmental entity. They are an instrumentality of the state.
Okay, great.
And think about it, kind of the core test there is the state kind of sidestepping the Public Records Act by handing off its normal duties to a non-governmental entity? And if you start to get a little bit of that vibe, it's likely that this non-governmental entity is going to be considered an instrumentality. Literally, you're using it as an instrument to carry out the duties of government.
Great.
We can skip past the physical form or characteristics, and we can talk about what a request looks like. I touched on this. The request does not have to be articulate. It doesn't have to be precise. It doesn't have to arrive at your person in a specific manner. It can be delivered by mail, email. It can be requested live and in person in the hallway of the State House. If that last form happens, the one thing that I would recommend is just asking as politely as you can the requester, please send me an email. And the reason is that gives you a basis for actually evaluating what the request is, so that you are meeting the exact terms of the request when you start to do the search for records. Having it written is extremely helpful for every step in the process that comes later.
What if it's already posted somewhere? I'm just looking at your example. Can you send me a copy of the draft? Is it my response? What if it's already on the website?
Proactive disclosure is one of the best parts of this area of law, which is we post so many of the legislative records on the General Assembly's website that you can just say that is already available to the public.
Great.
It is proactively disclosed. Go to the website. Here's the link. Here's where you can find similar documents. Do your own research.
Great.
Maybe that last statement wasn't the most polite. You have the ability to do your own research. All right, basic mechanics. Member of the public makes request. The custodian then has a duty to respond. And the shortest timeline, which is the usual timeline, is 3 business days. For you all, that means 3 legislative days, because those are the days where you are conducting business and you are in the office, so to speak. There are certain circumstances where that time period could be extended. 7 calendar days or 10 business days. There are legal tests that come into play there. The most typical timeline when we get some of these larger requests is the extended up to 10 business day timeline. And that occurs when, for example, the request is so voluminous and expansive that it cannot be completed within the normal timeline. So the first example,
Sorry, Tucker.
You're over, Tom.
I was anticipating perhaps another evacuation.
No, that has nothing to do with you.
Potentially.
So, where were we? The 10 business days, the first example that I gave a request. Please send me every email containing the word fish sent by the Department of Fish and Wildlife for the last 10 years. You can anticipate there would be 70,000 emails to review. That would be an instance where you'd say that is not feasible under the normal timelines of the Public Records Act. You might not even assert the 10 business day timeline because that wouldn't be feasible. You would use an out that is available in the Public Records Act to request that the requester narrow what they're looking for. And there's no teeth in the Public Records Act to make them do that. But the only requirement underlying the procedures here is that you make a good faith effort to meet the demands of the request. So you do what you can in 10 business days, perhaps you release what you've reviewed, and then you say, if you would like to continue, it's gonna have to be an extended timeline. There are fee provisions built into the Public Records Act, based on Supreme Court decisions. They only apply if the requester is receiving copies of the record. Public Records Act draws a distinction between inspection and copying. Inspection is always free. You can put your eyeball prints on any public record for $0. As soon as the agency has to commit time to preparing and providing a copy of the record to the person to keep, a fee applies for any time over 30 minutes that is invested in the preparation and copying of those records. And of course, the actual cost of printing if you're going to be providing printed copies. The exemptions are the most expansive part of the Public Records Act. I provided this year's list of statutory exemptions. There are 294 currently in the Vermont statutes annotated. The primary exemptions are within the Public Records Act itself. So in 1 VSA section 317 subsection C, there are 43 individual exemptions baked right into the Public Records Act. And one thing that I note is that this is just those in statute. And the very first exemption is any record that is designated confidential by law. That doesn't mean state law, that means by law, federal law, state law, potentially under C4, common law. So the protection of privacy interests through exempt information is very expensive. And there's a lot of interesting exemptions in here. I would recommend that you do at some point take a look at some of the exemptions that are listed because your committee will deal with some very specific material that may be exempt and private. Thinking, does this committee deal with cybersecurity? Cybersecurity, right? Very critical, confidential subject, especially from the state interest perspective.
And that's something you would advise us on. If there's a records request, I would assume the first thing I would do would be forward that to you, and you would then say, well, you could consider these, this is exempt, okay.
Yes, I think that's one of the last slides is my final points. I'll give them to you now, give you the sneak preview or the spoiler. I don't know if it's spoilers, I don't know if you're having very much fun right now, but time is of the essence. So as soon as you receive a request, it's time to act. And that is, if you want to use my services, reach out to me immediately. The timelines are so compact in some of these cases, and some of the privacy interests involved and the records you hold are so intense that I need as much time as possible to be able to perform the search, evaluate the records for potential exemptions, and then consult with you about what you would like to do. So we just, covered in 15 seconds the 294 exemptions just in Vermont law. But an important note about them is that very few of them are mandatory. Many of them are discretionary, and it is up to the public agency to balance the public interest in disclosure of the records against potentially an individual's privacy interest to determine which is more weighty. You're gonna redact the home phone number that one of your constituents included in an email, or are you going to release it? What's the public interest in that information? If you're on one of the healthcare committees and you're dealing with a bill around a particular illness, and you have received emails from constituents with that illness where they disclose their experiences and hardships, are you going to release those records redacted, or are you going to withhold them entirely in order to protect that confidential medical information? So there are weighty decisions to be made here, and they take time. So act fast.
You started by saying, don't be scared,
Don't be scared.
but I'm scared. Suppose somebody sees me texting and says, what did you just text to your chair? Is that a public records request?
The specific words that you use don't sound like one yet, but it would always be good to clarify with that individual whether they're asking for the text.
And when your first slide said something about a request looks like any, of course, there's no form for a request. So a person doesn't have to say, I'm making a public records act request. They just have to say, really ask you anything that might be recorded somehow. And actually, well, our deliberations are recorded and posted on the internet, but yeah, I guess I'm trying to see where the limits are here. And,
Not agree.
And, you know, somebody sends me an email and says, why did you support that, or whatever. I mean, you know.
You've given a bunch of great examples for me to say not every question is going to be a Public Records Act request. If they've identified some document, record, recorded information that they are seeking, that's when you look at it and say this is a public records request. No matter how it's buttressed, no matter how vague it might be, if there's, you know, an articulated record there, that's when you know you have a request. So your question about what did you just text your chair, if you responded by saying, I just asked when we're having lunch. You've responded to the question. It doesn't really sound like they said, I would like to see what you just texted your chair. Show me. Give me a copy of what you just texted your chair.
I mean, they might be suspecting and accurately that I'm texting about, you know, don't pay attention to that person or something like that, you know, whatever. You know,
Don't pay attention to Tucker.
Pay no attention.
You know, or, you know, whatever. Something substantive about something that we're doing. So they might reasonably suspect that a text is being sent on that about something that we're doing. And if they ask to see that text, then that would be probably
That would be the public records. Yes, which could happen, but I wouldn't construct the parade of horribles that could follow the Public Records Act here too soon. And most of the records produced that are public records under this definition are mundane records. Something that I didn't bring up is that privileges are exempt here. So when we talk about attorney-client privilege, you know, the legislative offices have statutory privileges extended to legislators when you seek legal advice from legislative counsel, seek fiscal advice from JFO, HR. There are specific confidentiality provisions built in there. And then there is this universe of the constitutional legislative privilege, which we don't have time to dive into today because I would have to bring you back to pre-colonial Great Britain and the Tower of England, where early members of parliament were being chained to the wall and tortured for information at the threat of, the king executing them publicly, and bringing us into the formation of Vermont and the enshrinement of a legislative privilege in Article 14
You
of the
just
Vermont
did.
Constitution.
Okay, let's say that.
The details are very interesting. We only have one Vermont decision on the existence of the legislative privilege, which confirmed not only its existence, but its scope, which is that records created within the legitimate sphere of legislative business are privileged and can be asserted through 1 VSA 317C4, which covers common law privileges.
Interesting, okay.
And
I'm sure we'll be talking.
yes,
Right. I was, are you gonna talk a little, okay.
yeah, I'm
I'm a little bit unclear on that one. Okay.
There's two
I'm unclear on privilege.
privilege.
Okay.
Yes. So a privilege, highest form of confidentiality, and can even be asserted in the face of, for example, a judicial subpoena for records. Legislative privilege has been examined in all of the states that have a constitutional provision providing the privilege to members of the legislative branch. And it has even been interpreted in the context of redistricting in the state of Florida, where there is no constitutional provision and where there's a statute prohibiting the use of legislative privilege or any common law privilege to withhold records in the case of a subpoena. But the Supreme Court of Florida said, well, actually, that is a massive separation of powers issue. So even if you do not have an enshrined legislative privilege, it exists simply because of the separation of powers. Again, this is just 10 seconds of, 2 hours of my TED talk about the legislative privilege.
Yeah.
If you have any specific questions, I'm happy to talk to you individually, and especially about the decision. So we talked already, we can move past the what exemptions to the PRA apply to legislative records and other exemptions. What happens if you receive a public records request? Ledge Counsel, myself, and I'm a team lead for a group of attorneys in Legislative Counsel. And the attorneys on my team will also now be assisting me with public records consulting and representation for all of you. We can provide assistance in complying with the requirements of the Public Records Act. Let us know as soon as you receive the request. There are a number of options that legislators have. You can either perform a dislocated search, which means you do all the legwork of finding responsive records, or if you use your legislative email account for all of your legislative business, then IT can structure what's known as an e-discovery search, where I give them the structure of what the request is actually asking for, its temporal limitations, the keywords that are associated with the request, and in a matter of minutes, all of the responsive records on your legislative account get deposited into a confidential inbox that allows me to review just the 9 records that are responsive and not the 15,000 desktop folders. So that is one avenue. Provide legal advice on the application of exemptions, and then help you prepare if you are going to withhold or redact what's known as a certification letter, which is a letter that is required by the Public Records Act that certifies the basis for any exempt information and informs the requester of their right to appeal. first to the head of the agency. And I was waiting for the one head turn, which
Yeah.
is if you receive a request as an individual legislator, you respond to the request and then you are the destination of appeal because you're an independent constitutional officer. And then after, there is a right to appeal to the Superior Court based on a further denial upon appeal
Oh,
by
interesting.
you all
So the appeal comes to us
first.
first.
And then if you deny the appeal and say no
Then it moves, okay,
to the Superior Court.
that's interesting.
We'll move on to the records management part of this. Keep your legislative work on the legislative accounts. I would suggest coming up with some system of organization for the work that you're doing. It doesn't have to meet the National Archives standards for records preservation, but it should be some sort of system that you can use individually to understand where specific records are. Organizing by bill number and subject is probably a good place to start, because that's where most of the requests that you may receive in your time as a legislator, that's what they'll be about, the work that you're doing. Use uniform and consistent file names so that you can easily search for and retrieve any files that are subject to a request. You'll receive emails, this is on the very last page, about litigation holds. The General Assembly periodically receives notice from the Attorney General when the state is subject to a suit and it involves underlying challenges to a particular act. We will receive a litigation hold that says you may not alter or destroy any record related to X subject. You will receive those. It's another, I put it in here because it's another time for me to say, don't be scared when you receive them. It doesn't mean you're being sued. It means that the state is being sued and we might have some records that are relevant to the decision. The action.
Yeah, Representative Howard.
Do deleted emails really deleted, or is this DB deal that they carry on in perpetuity somewhere?
If you permanently purge or email, it goes away. Yes.
And until you receive that order not to destroy anything you have, anything you've thrown in the basket at home, I don't need to take out of the trash.
Correct. Yes. So there will be specific directions in the litigation hold about how to manage your records and what not to automatically purge. Because we are currently subject to so many overlapping litigation holds, none of our systems automatically purge. Everything is preserved unless you click and say that you want to delete or purge something.
So if I don't know somebody's asking for a public records request, if I don't recognize it as a public records request, I'm not obligated to do anything special. As long as I don't knowingly purge something or don't respond. If I don't recognize it, I'm not at fault.
I don't know if a court has interpreted whether this has to be a knowing standard, and I can send you the specific statutory language about not altering or destroying public records absent authority to do so.
And Tucker, you made such an important point that I'll just share with all of us, just as colleagues. The organizing of your emails and the separation between your legislative email and whatever Gmail or personal account you might have is such good practice. And I do it religiously. You know, if constituents reach out to my personal address because they have it, or they've known me for 30 years, I either write back and say, please write to my legislative address, or I forward it to my legislative address and respond from there and say, this is a legislative conversation, please use my legislative address. And so I increasingly over the years I have a great storage system on my Outlook for all of my legislative emails. I keep everything in folders as you've suggested. And, my personal accounts at this point are really reserved for like campaign, when he says political, like campaign stuff. You know, I'm gonna do a campaign event. I never ever use my legislative email address for campaign related stuff or political party stuff. That's all in another. So just have that bright line in your mind.
So, if somebody addresses you about legislation on your personal address, you move that to your legislative
I do.
address? And am I responsible for that personal legislation if the person isn't my constituent? Any citizen of Vermont can call me about an issue, or not call me, email me about an issue, and am I obligated to the guy from?
I think that's more of a ask your colleagues question and maybe a council question, although maybe there's a legal response to that. I can tell you what I do. Tucker?
I would just say that under the Vermont Constitution, Article 20, every citizen of the state has the right to petition and instruct their representative, capital R. So any citizen under that constitutional article has the right to petition and instruct you. But as far as your management of response to anyone who reaches out to you, that is up to your discretion, unless it's a public records act request.
Right. So there is they have the right to ask, and we can talk about, you're gonna have to make time management decisions, honestly, about whether you respond to every email. We receive many emails that are addressed to every single member of the House. I have typically evolved the practice of writing back if they're my constituent, or if it falls under my committee jurisdiction. Or maybe you coordinate with a rep from their district. Say, saw this letter from your constituent. Yeah. And never reply all. And everybody gets reply all. Tucker, yeah.
And what happens if you don't answer any email?
You may not get reelected.
You won't get reelected.
Or maybe you will.
Your legislative council will be very concerned that you haven't responded to them on a number of issues.
Yes.
All right. That was so helpful.
Thank you.
Tucker,
all
thank you so much for being here. I think we're adjourned. We can go out live.